everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. In this video today, I'm going to discuss with you all the previous year MCQs from SEBI Grade A Legal Officer Examination 2023. प्रीवियस ईयर पेपर के क्वेश्चंस मैंने डिस्कस करना स्टार्ट किए थे फेज़ 1 के एंड मैंने अभी रिसेंटली पिछले वीडियो में फेज़ 2 डिस्कस करना स्टार्ट किया है. आई हैव डिस्कस्ड द फर्स्ट 25 MCQs फ्रॉम द पेपर and in this video today I will be discussing next 25 MCQs. So stay tuned to Legal Beat. Don't forget to subscribe. कोई भी queries हो, you can reach out to us by writing us an email on hello@iexamb.com. You can also call us on the number 9205524028 and visit our website www.iexamb.com for all the course details. You can also activate the demo of all the online courses and check it out. SEBI Grade A Legal Phase 2 paper, जिसका law paper है, that is the second paper we are going to discuss in this video today. This is the second part of the Phase 2 paper. SEBI Grade A Legal Officer selections. There have been 12 selections out of 25 from iExamB. So we are again congratulating all the SEBI legal officers, and also we are very glad to announce the same. From 2020 onwards, we are having selections from our students in SEBI legal officer posts, and this is the detail of our SEBI Grade A Legal online course. We have live sessions, PDF notes, descriptive questions, and all the content that is very crisp and relevant from exam point of view, along with interview guidance as well. Details के लिए आप जैसे मैंने आपको कहा इस नंबर पे कॉल कर सकते हैं. Starting with the 26th question, as I have started the first 25 questions in previous video, I have covered it. Today we will continue with 26th question up till 50 we will be completing in this video today. As per the Indian Evidence Act, the court may presume that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen. Is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. Is either the thief or has received the goods knowing them to be stolen even if he can account for his possession. Both C and D. So ये Evidence Act से पूछा गया presumptions related, and that is talking about a specific situation. A man who is in possession of stolen goods soon after the theft. Option C is correct, that is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. So this is covered under section 114 of the Indian Evidence Act. Court may presume existence of certain facts. So this is specifically talking about A point, that a man who is in possession of stolen goods. यही situation को as it is यहाँ पे question के form में discuss किया गया है. What is the period of limitation if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years under the CRPC? 6 months, 1 year, 3 years, 7 years, no such limitation is laid down. So what has been asked over here? What is the period of limitation in this particular case? Correct answer is C, 3 years. Section 468 of Limitation Act talks about bar to taking cognizance after lapse of the period of limitation. Section 468 of CRPC. CRPC 468 talks about a bar to take cognizance after lapse of the period of limitation. As per section 219 of CRPC, when a person is accused of more offences than one of the same kind committed within the space of 12 months from the first to the last of such offences, whether in respect of the same person or not, he may be charged with and tried at one trial for any number of them not exceeding 2, any number of them not exceeding 3, any number of them not exceeding 5, any number of them which may also be exceeding 3, any number of them which may also be exceeding 2. So you have to very carefully answer this. What can be the correct answer over here? Correct answer is B, any number of them not exceeding 3. Section 219, as they have also mentioned in the question itself, the section number. So that is talking about 3 offences of same kind within year may be charged together. So correct answer is any number of them not exceeding 3. If any court has a reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear. Such court may publish a written proclamation requiring him to appear at a specified place and at a specified time not less than 7 days from the date of publishing such proclamation. Such court may publish a written proclamation requiring him to appear at a specified place and at a specified time not less than 30 days from the date of publishing such proclamation. Such court may publish a written proclamation requiring him to appear not less than 45 days from the date of publishing such proclamation. None of the above. Such questions may look very descriptive, but you have to be very careful when you are reading the questions. You have to be very careful. The questions are actually easy, but they look lengthy, so they look scary. But that should not happen. The questions are easy and scoring. Just you have to be very careful when you are reading the questions and also the options. Correct answer is C. Such court may publish a written proclamation requiring him to appear at a specified place and at a specified time not less than 30 days from the date of publishing such proclamation. Covered under section 82 of CRPC. It's a very common section, proclamation for person absconding. As per CRPC chapter 21A, it does not apply where offences affecting the socio-economic condition of the country, offences have been committed against women, committed against a child below the age of 14 years, either A or B or C, either B or C. So this is talking about the application of 21A. 21A is what? It is plea bargaining. It is not applicable to A or B or C. All these are the conditions. Applicability of this chapter is covered in section 265A and all these three have been covered over there. इसमें से कोई भी एक भी condition हो, so this will not be applicable. Any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits in the presence of a police officer a cognizable offence, a non-cognizable offence, cognizable offence punishable with imprisonment for a term which may be less than 7 years, cognizable offence punishable with imprisonment for a term which may extend to 7 years, whether with or without fine, either A or C or D. So the correct answer over here is A, a cognizable offence. Section 41 talks about it, when police officer may arrest without a warrant. Which of the following is not a criminal court? Executive magistrate, court of small causes, judicial magistrate first class, judicial magistrate first class, judicial magistrate second class, both A and B. Very easy question this is again, I would say. B, court of small causes. This is not a criminal court. So we have to be very clear with the hierarchy of the courts and also with the type of court it is, whether it is criminal, whether it is civil and so on. Whoever threatens another with an injury to his person, reputation or property with the intent to cause alarm to that person or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do as the means of avoiding the execution of such threat, commits trespass, extortion, defamation, criminal intimidation, criminal conspiracy. So the correct answer over here is D, criminal intimidation. Section 503 of IPC talks about this concept and that has been actually picked up as it is from the section. Direct question hai ye. Whoever intentionally puts any person in fear of any injury to that person or to any other and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security, commits trespass, extortion, defamation, criminal intimidation, criminal conspiracy. Correct answer is extortion. Section 383 of IPC covers the concept of extortion. Again, similar kind of question like the previous one, but both these concepts have been covered from IPC. Here you have to be very clear with the ingredients. If you are clear with the ingredients, such kind of questions from IPC can be very simple for you to answer. A cuts down a tree on Z's ground with the intention of dishonestly taking the tree out of Z's possession without Z's consent. Here, as soon as A has severed the tree in order to such taking, he has committed theft, dacoity, trespass, robbery, none of the above. This is a very interesting question. ये कई बार काफ़ी जुडिशरी एग्जाम्स में भी आपको देखने मिलेगा. ये इलास्ट्रेशन है जिसको डायरेक्टली पिक किया जाता है. इस तरीके के क्वेश्चंस भी आप आईपीसी से ज़रूर एक्सपेक्ट कर सकते हैं. The correct answer is A, theft. Section 378 talks about theft. Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Criminal conspiracy as per IPC means what? When two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by legal means. Two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by legal means. Now this is what is the difference between the options that you have to check it out, and you have to observe that these are the options, and the options are having slight differences in between. So the correct answer is A, when two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by legal means. Section 120A talks about criminal conspiracy. That whoever by words either spoken, written, or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life to which fine may be added, or with imprisonment which may extend to 3 years, for life to which fine may be added, or with imprisonment which may extend to 2 years, which fine may be added, or with fine. Imprisonment for life to which fine may be added, or with imprisonment which may extend to 3 years, which fine may be added, or with fine. So this is all a question about punishment. First you have to identify the offense over here. Correct answer is E, imprisonment for life to which fine may be added, or with imprisonment which may extend to 3 years to which fine may be added, or with fine. So इसमें 3 categories की seriousness and offense के ingredients के हिसाब से ये 3 categories में होता है, and this is the offense of sedition. Section 124A talks about it. Which section of IPC lays down provisions relating to doctrine of just necessitatis? Section 79, 80, 81, 82, 83. आईपीसी से आप काफ़ी सारे कंसेप्चुअल क्वेश्चंस एक्सपेक्ट कर सकते हैं, जो जैसे मैंने पिछले वीडियो में भी डिस्कस किया था. फर्स्ट 25 क्वेश्चंस में आया था एक क्वेश्चन डोली इनकम टैक्स से रिलेटेड. तो इस तरीके के डॉक्ट्रिन्स एंड एवरीथिंग यू कैन एक्सपेक्ट फ्रॉम आईपीसी. सो दिस जस्ट नेसेसिटाटिस इज कवर्ड अंडर सेक्शन 81, डॉक्ट्रिन ऑफ नेसेसिटी. Law has to be broken to achieve a greater good. That is what is act likely to cause harm but done without criminal intent and to prevent another harm or a greater harm. That is what is covered under section 81. It's a defense. It's a general defense. A makes an attempt to steal some jewels by breaking open a box and find after so opening the box that there is no jewel in it. It's also a very common illustration. यहाँ से भी कई बार competitive exams में questions आते हैं. What he has done actually, whether it is theft और he's guilty under which section, ऐसे options दिए हुए हैं. ये सारे ingredients इसलिए आपको पता होना ज़रूरी है ताकि ऐसे illustrations देख के आप confuse ना हो जाएं. So the correct answer over here is C. Done an act towards the commission of theft and therefore is guilty under section 511 of IPC. Punishment for attempting to commit offences punishable with imprisonment for life or other imprisonment. Where several persons are engaged or concerned in the commission of a criminal act, they shall be guilty of offence, may be guilty of different acts, may be guilty of different offences by means of that act, may be guilty of same offence by means of different acts, guilty of different offences by means of different acts. Correct answer over here is C. May be guilty of different offences by means of that act. Section 38 talks about it. As per IPC, what is the punishment for concealing with intent to facilitate design to wage war? Imprisonment, which may extend to 10 years, 10 years or fine, 7 years and fine, 10 years and fine, 12 years and fine. What is the punishment for concealing with intent to facilitate design to wage war? Correct answer is D. Imprisonment for a term which may extend to 10 years and shall also be liable to fine. Section 123, concealing with intent to facilitate design to wage war. When is a person said to abet the doing of a thing as per section 107 of IPC? A person abets the doing of a thing who instigates any person to do that thing. Person abets the doing of a thing who intentionally aids by any act or illegal omission the doing of that thing. Person abets the doing of the thing engaging with one or more other person. A person in any conspiracy. All these are the different modes which you will find under 107. So the correct answer over here is D, either A or B or C. Abetment of a thing, you can see first, second, third, all these are different types of abetment that are covered in 107. So the correct answer is A or B or C, that is option D. Whoever being a public servant and being legally bound as such public servant not to purchase or bid for certain property, purchases or bids for that property either in his own name or in the name of another or jointly or in shares with others shall be punished with imprisonment which may extend to 2 years, 2 years of fine, 2 years of fine or with both, 2 years or with fine or with both, and the property purchased shall be confiscated. 3 years or with fine or with both, and the property purchased shall be confiscated. Correct answer is D. Imprisonment which may extend to 2 years or with fine or with both, and the property purchased shall be confiscated. Section 169 of IPC talks about. All sums realized by way of penalties under the SEBI Act shall be credited to the Consolidated Fund of India, Contingency Fund of India, Reserve Fund of India, Securities Appellate Fund, either A or B. Sums that are realized by way of penalties under SEBI Act will be credited to which fund that has been asked over here? Correct answer is A, Consolidated Fund of India. This is a direct question from SEBI Act section 15 JA. Crediting sums realized by way of penalties to Consolidated Fund of India. As per SEBI Act, the Securities Appellate Tribunal shall consist of a presiding officer and such number of judicial members and technical members as the dash may determine. President, Securities Board, Central Government, Competent Authority, Prime Minister in consultation with the Committee of the Board. ये भी एक डायरेक्ट क्वेश्चन है सेबी एक्ट से. सेबी एक्ट से रिलेटेड काफ़ी सारे डायरेक्ट क्वेश्चंस पूछे जाते हैं इंपॉर्टेंट लैंडमार्क टॉपिक्स से, उस एक्ट के इंपॉर्टेंट सेक्शन से. So this is also a scoring area for you if you are able to trace out which are the important areas and you are able to thoroughly prepare yourself with that. Correct answer is C, Central Government. Section 15L talks about composition of Securities Appellate Tribunal. As per provisions of SEBI Act, all questions which come up before any meeting of the board shall be decided by a majority of votes of the member present and voting. And in the event of an equality of votes, Chairman has a casting vote. Chairman in his absence, the person presiding shall have a second or a casting vote. Chairman and in his absence, the person presiding shall have a second or a casting vote. Now you can see B option is chairman or in his absence. C option is chairman and in his absence. Small differences have been given in the options. Most appropriate one you have to choose, that is E, chairman or in his absence the person presiding shall have a second or a casting vote. Person who is presiding shall have that. Like in option D it has been given senior most member. So ये आपको काफ़ी careful रहना है. Section 7 of the SEBI Act talks about the 7 clause 3. According to SEBI Act, Securities Appellate Tribunal shall be bound by procedures laid down by CPC, not bound by CPC, not be bound by CPC and shall not be guided by the principles of natural justice, Be bound by procedure that is laid down in CPC as well as guided by principles of natural justice. Not be bound by the procedure of CPC but guided by principles of natural justice. Correct answer over here is E. Not bound by the procedure but guided by the principles of natural justice. Section 15U directly talks about this procedure and powers of SAT. In this point has been specifically covered. Under the SEBI Act and any pooling of funds under any scheme or arrangement which is not registered with the board or is not covered under section 11AA3 involving a corpus amount of dash shall be deemed to be a collective investment scheme. 100 lakh rupees or more, 100 crore rupees or more, 100 crore rupees or less, 100 lakh rupees or less, 200 crore rupees or more. Correct answer over here is B. 100 crore rupees or more. Section 11AA talks about the collective investment scheme. Amended provision है, डबल A है उसमें, याद रखिएगा आप इस स्कीम के बारे में भी कोई भी क्वेश्चन आ सकता है. What is the qualification for appointment as presiding officer of Securities Appellate Tribunal? Is or has been a judge of the Supreme Court, is or has been a Chief Justice of High Court, is or has been a judge of Supreme Court or a Chief Justice of a High Court or a judge of High Court for at least 7 years, is or has been a judge of the Supreme Court or a Chief Justice of High Court or a judge of High Court for at least 5 years, is or has been a judge of the Supreme Court or a Chief Justice of a High Court or a judge of High Court for at least 7 years. Correct answer is E. Is or has been a judge of the Supreme Court or a Chief Justice of a High Court or a judge of High Court for at least 7 years. So section 15M of SEBI Act talks about this qualifications for appointing as presiding officer, judicial member and technical member. So सारे qualifications इसमें covered है. Section 15M talks about it. Correct option is E. Is or has been a judge of Supreme Court or Chief Justice of High Court or judge of High Court for at least 7 years. Last question for today's video. According to Section 7 of Securities Contract Regulation Act 1956, every recognized stock exchange shall furnish the dash with a copy of annual report, and such annual report shall contain such particulars as may be prescribed. Securities Tribunal, Central Government, Competent Authority, Securities and Exchange Board of India, Central Government on the advice of SAT. So, the correct answer as per Section 7 of SCRA is B. Central Government. Annual reports are to be furnished to the central government by the stock exchanges. So, this was all that I had to cover the next 25 MCQs. Now, from phase 2, paper 2, 20 more MCQs are left. This I will be covering in the last part, that is the next video of the series. And if you have not checked out the remaining videos, I would suggest all of you to check out the remaining videos of this series. This will be will definitely help you out in your preparation. कोई भी queries हो, do reach out to us and don't forget to subscribe to Legal Bee.